Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. All right, we are here at 12 o'clock right now, ready to get underway. Thank you everybody very much for joining us this afternoon for part 2 of our mediation boot camp, which is the mock trial or mock mediation in action. Today we will be looking at the case of Carrie Jones versus Merch Co. And so I'll read out the fact pattern in just a moment here. So now I would love to turn over to introducing our panelists today for our mock mediation. In the role of plaintiff's counsel, we have Bill Munoz, who is a partner and co-chair at Freeman, Mathis, and Gary LLP, with over 25 years of expertise defending professionals in high-stakes litigation, including legal malpractice, complex liability, and today, an employment dispute. So thanks for joining us, Bill.
Thank you.
And on the side of the defense counsel, we have Courtney O'Brien, who is a deputy city attorney for Oakland with extensive litigation experience in civil rights, employment, premises liability, and she's represented both public and private entities in state and federal courts. And today we'll be representing our defendant. Thanks for joining us, Courtney.
Thank you.
And in the role of mediator, we have Peter Linn, a mediator with ADR Services, Inc. He is a seasoned mediator and litigator. He has nearly 30 years of experience and knows how to navigate the intricacies of litigation, having really gained a profound understanding from his many years as a litigator there and now as a mediator. So thank you for joining us, showing your expertise, Peter, and hopefully getting us to a settlement today.
Thank you.
And now I will go ahead and pull up our fact pattern to introduce the case for us. Give me a quick moment there. All right. So our case for today is Carrie Jones versus Merch Co. So Carrie is an unmarried woman, divorced with 2 kids. She's 38 years old and college educated. She was hired as an account manager for Merch Co. 4 years ago. She received pay raises and merit bonuses for 3 of the 4 years. During her 4th year of work, she was disciplined by her male supervisor, Mike. You may see in the briefs he's named Macho Mike, for excessive absences and placed on a performance plan. She did not receive a raise or a bonus for her 4th year. Mike has been with the company for 10 years, is married, and also has 2 kids. Carrie alleges Mike was hitting on her at work, flirting, asking her out, making sexually suggestive comments. Carrie, knowing Mike was married, ignored the advances. There are no witnesses to any of Mike's comments or actions. Mike has 1 prior complaint by a female coworker 7 years ago. The company investigated but was unable to find any evidence to support the claim, so no action was taken. Carrie alleges her absences from work were approved verbally by Mike, but when Carrie began to ignore his advances, Mike got angry and used the excessive absences as a basis for punishing her. Carrie made a formal complaint with HR in compliance with the company's policy manual. The company hired an independent investigator who conducted a 2-week investigation. The investigator found an email from Mike to Carrie that stated, "Carrie, are you available this Friday evening?" with a winking emoji face. There was no response to the email from Carrie. Given there were no eyewitness accounts to the events and no evidence corroborating Carrie's allegations other than a cryptic email, no action was taken and the matter closed. 3 months later, Carrie quit and has now sued her former employer and Mike for constructive termination, hostile work environment, sexual harassment, and retaliation. I will also post a copy of this fact pattern in the chat in just a moment here, along with the mediation briefs. So without any further ado, I will hand it over to Peter to get us underway.
All right, Bill, Courtney, I want to thank you. I've read both your briefs, and I want to just let you know that from what I've seen in the briefs, this is a really good case to mediate. And I think that you guys and your client should be commended for submitting to the mediation process to see if we can get it resolved. Bill, I'd like to spend a little bit of time talking with you about the case if I could. So Courtney, if I could, I'm going to take a few minutes to talk with Bill, no more than maybe 5 or 10, and then I'll come back and talk to you for a little bit, okay?
All right, sounds good. Thank you.
Okay. Bill, how are you?
Good. How you doing, Peter?
Good. How's your client doing?
She's pretty emotional. I mean, this is a big deal for her. As a single mother of two. This has really been tough on her. Reliving all this harassment by Macho Mike. It's been tough. It's been tough,
Yeah.
and so there's a lot of emotion here.
Is she available today to talk to?
She's available, but I'm a little hesitant to to let her talk to you, because I think she's so emotional. Um, she's okay talking with me, but I'm a little concerned that if someone is maybe pressing her a little bit on some of the issues, that may just send her off the deep end. So I'm a little concerned there.
I don't want to do that. I don't want to do that. So I've read the brief, but tell me what's not in the brief that I need to know. Tell me what's going on. Why is it that it seems like this was not much of a big deal, but what am I missing in as far as those facts?
Well, I think the problem is that everything was fine, so to speak. I think there was some friendly banter going on between Carrie and Macho Mike, but and Carrie thought nothing of it. The guy's married. I'm not interested in any work romance. It's just coworkers, getting along. But when it started to change a little bit, and the friendly banter became something more like, hey, let's go out to lunch, and then it was let's go out to dinner, and then he's starting to make suggestive comments about the way that she's dressed and how good she looks, virtually every day. It started to get a little weird, and she kind of blew it off initially, as for whatever reason. And she was taking care of her kids and would go and hey Mike, I need to leave work early, or I can't, I'm not going to be in tomorrow, because she had to do something with her kids or take her kids to school or doctor, whatever, and it was never a problem. It was only when after this first or second time that he asked her out to dinner, and she said no, did things start to change, and for no other reason. I mean, her work product has always been good.
How long has all this been going on?
It's been going on really this last year. The first 3 years, she had good performance reviews, got bonuses, and no issue. But again, the asking, the banter and stuff, and asking, that didn't occur until this year. And I don't know what, it may be something happening with Macho Mike and his wife. I don't know, but it intensified this year. I mean, it really came about this year. And, given her past track record of being such a good employee, there's only one, I mean, you can only point to one thing here as to why the negative performance, why no bonuses. And that is because Macho Mike dinged her after, and it time wise, temporally, it was right after she refused to go out on a date.
Did your client ever talk to anybody about any of this stuff? Has she reported to you that she spoke to anybody?
Not until after the negative performance review that she then reported it to HR because she thought it was retaliatory, for her not succumbing to his advances. But prior to that, she, you know, like I said, she kind of blew it off, didn't think much of it, thought it was more of the friendly banter. It's only, you know, when he started commenting on her looks and, you know, how good she looked, and then the dates, you know, a lunch here and there is, I think that's not uncommon with colleagues. Um, but when she started to perceive it as something different and, you know, something more sexual in nature, that's when she declined. That's when she gets dinged for it. That's when she reports it.
Okay, so she didn't talk to any friends or coworkers and say, yeah, Mike keeps asking me out or anything along those lines.
No, she didn't.
Okay.
Because she didn't, again, like I said, she didn't think much of it at that point in time until it got weird. And then she went to HR.
Is she currently working? Did she get another job?
She's not. She's been so distraught. I mean, this is just kind of broke her. I mean, she just kind of is losing faith in working for, you know, anyone, male or female, I guess at this juncture. So she doesn't necessarily. I mean, she's looked, but not probably as intensely as she should. I mean, recognizing, I know there's some mitigation issues, but I think from mentally, she's pretty messed up from this situation.
And remind me again, if you can, what was she making? Was it on an hourly basis or salary when she was with Merchco?
She was making like 75,000 a year. Yeah.
Okay, with the bonuses, right?
Right.
All right. Helpful. Anything else I need to know before I go and talk to Courtney that you think is important? And it can be confidential as well. Let me just tell you that anything you tell me is absolutely confidential. I'll make a note and I'll make sure not to disclose to the other side. Otherwise, the information that we convey back and forth, I'm going to assume that it's okay to go ahead and talk to the other side about, okay?
Sure. You know, I think you know, there's been, I'm aware of another incident that Macho Mike had. They kind of downplay it, but you know, I think that's the Me Too issue. That's probably going to come in at trial, and that's not going to bode well for them. I think secondarily, their investigation was a ruse. That email is not cryptic in any way. That's pretty clear that the guy was asking her out. You don't send, "Hey, what are you doing on Friday?" and with the winky emoji. That is pretty clear. I don't think that's going to bode well for them, but yet they keep downplaying it. I think that's going to come back and bite them in the butt if they don't take that seriously. You know, I'm at $250,000 already in fees in this case, and it's only going to get worse. So they need to step up and get real.
I saw your demand was for 750. Is that the first time that demand's been made?
It has. You know, my client wanted to ask for a lot more, and you know, I thought, if we're going to go to mediation, we don't want to scare them right out the door, and ask for some ridiculous number because you want to send the right message. You know, here we want to resolve the case, but we're not going to, you know, give away the house to do it. And so I thought we talked about it, and I thought that was a fair number to start at.
Okay, you and your client are willing to move off that number though, right?
Well, I know I am. You know, my client, you know, I told her, you know, I obviously explained the process to her, and you know, it's a negotiation, and it's the whole thing of mediation is to compromise. So you got to be willing to, you know, put a number out, recognizing that's not going to be your final number until you get to that point where it is. And so I think I got her on board. She will come off the 750.
Okay. Tell me this, where are you on the process of obviously your client has never been through this before, right? This type of litigation. Okay, this is the first time. Right. Where do you stand on procedural status, or you're in discovery, obviously. What's been done there?
Not a lot. I've interviewed like the person who was involved in the prior incident. I interviewed her. She's going to make a really good witness. I have some PMQ depots set up for Merchco, and I'm getting I've already noticed Macho Mike's deposition. I'm gonna depose his wife too, because I'm pretty sure his wife doesn't know what's going on. And so I'm sure he's not going to be particularly happy about that. And so that should be incentive for them to really think about settling the case. Although Mike is not personally named as far, in the lawsuit, I'm going after Merchco. But it's all going to be good. So that's where we're at. My client has not yet been deposed. But I think
I thought your client had been deposed. I thought
she had. Oh no, you're right. Sorry. Yeah, I was thinking of a different case. And I thought she made a good witness. So I think she'll be very sympathetic to the jury. But that's kind of where we're at. We kind of held off on all the other depositions while we try to settle the case.
Okay, excellent. I'm going to go because I'm up against the time wall now for the amount of time I told Courtney I'd be away. So let me go talk with her for a few minutes, and then I'll come back, and then we can figure out a game plan going forward. Okay.
Very good.
All right. Thanks.
Yep.
Courtney, are you there?
Hi, I'm here.
Oh, I'm good. How are you?
Good.
Good. Bill sort of filled me in on procedurally where things are at. Sounds like he's got some depositions that are going to be scheduled. He hasn't taken them, but they're going to be scheduled. And I don't know. Has he sent out notices for those?
No, not yet.
Okay.
We've talked a little bit about availability, but no notices yet.
Okay. All right. So he's holding off on those. He's also, he said your client's deposition went forward?
Yes, it did. And, I mean, I think that it went well for us. Mike is, and by the way, we object to him being called Macho Mike. His name is actually Mellow Mike. He's a very, mellow. His only fault maybe that he is at sometimes maybe too friendly with his team. But he really loves his job. He loves his coworkers and he loves his family. And I think that came off in the deposition. It's unfortunate that maybe some of it was interpreted wrong, but there was absolutely no ill intent on Mike's part. And I think that was evident in the deposition. I think he will make a very good witness.
What's Mike's attitude regarding the litigation?
I think he's embarrassed. He regrets making if he did anything to make Carrie feel uncomfortable. That was not his intent at all. He sincerely thought they were coworkers and colleagues and friends. I think he has probably learned a lesson from this, but at the end of the day, when a sales employee has excessive absences, they're not making sales, and that's really what this comes down to. I know that Carrie disputes that her work product declined, but how could it have not? She was so absent from work so much that her work really did suffer, and that's what all of this is about, unfortunately. That it's trying to pass the buck, which is unfortunate for everybody involved.
Bill mentioned that there was a prior complaint by another employee, and he didn't go into all the details, so I don't really know what that's all about. But are you familiar with that?
I am, yeah. And I think we mentioned it briefly in our brief. Again, it was Mike has been an employee for 10 years and he has always had excellent performance reviews. There was an incident, a similar incident, where a female colleague misinterpreted and felt that she wasn't given the bonus that she deserved. And but that also was investigated and nothing was found.
Okay. Between you and me, do you think that ever sees the light of day inside the courtroom in this case?
I think it could. And that's definitely something that we are keeping in mind, even though we really do think that this is we really think that these allegations are very unfair, but we would like to try to resolve the case if we can.
Okay. And you're representing Mike as well as the company?
That's correct.
Okay, and is Mike facing any personal exposure to your knowledge?
Well, yeah, it sounds like he might be. You know, the carrier has reserved rights on any intentional conduct. And I believe that plaintiff is also seeking punitives. I don't, you know, I don't think that she's gonna be able to get any, but that's also something that the carrier would not cover. So it's possible. I think there's a remote chance of that, but again, we're trying to keep that in mind as well. So I'm trying to figure out what's best for Mike as well as the employer here.
Is there a reservation of rights letter that's been issued?
Yes, there is.
Okay. Do you know whether there's any talk by the carrier about possibly bringing a declaratory relief action on those issues?
That I'm not aware of that yet.
Okay. Do you know whether Mike has personal counsel?
He doesn't yet. You know, and he is a mid-level management employee, and that's really something we'd like to avoid if we can. He doesn't have any money to be able to hire his own attorney or personally contribute. So we're hoping we can try to avoid that.
Okay. No, I agree. I think that's a good plan. You know, candidly, from what Bill said, it sounds like it is a classic he said, she said situation, and there really aren't too many, or there aren't any other witnesses to what occurred. So it's a difficult case. But answer me this. Obviously, your best day at trial would be defending the case. What's your worst day look like? How do you evaluate that?
Well, you know, we really think that plaintiff, you know, she has a duty to mitigate her damages, and she is an educated employee with some really good work experience, and I understand she's not back working anywhere yet, which, you know, I think is pretty unreasonable. So we would think that our worst day would be something really in the neighborhood of what their demand is. So I think that their demand is way inflated, and this case should hopefully settle for much less than that. And you know, my client only has a $200,000 policy. So for them to think that they're going to get a large contribution from the company or from Mike personally, I think is unrealistic.
All right. So I assume you've probably spoken to your client about whether or not he needs to be looking to pull money out of his pocket, or that the company would need to pull money out of the pocket. Sounds to me like what you're saying is everybody really wants to settle this within the policy and then be done, if that's possible, right?
That's correct.
Okay.
Right.
They're aware though that there's a possibility that if this goes to trial, that they might have to all come out of pocket?
Yes, everybody's aware of that.
Okay. All right. Good. All right. What else do I need to know that I don't already know from your brief? Is there anything else?
I think you probably need to know that although both of my clients would really like this to get settled within the policy limit, I do not have authority for that from the carrier yet. So we're still working on that.
Okay. All right. And they're available by phone for you in case you need them.
Yes, they are.
Okay. All right. Let me go back and talk to Bill for a few minutes, okay?
Okay, thank you.
Yeah. Hey, Bill, are you there?
Yeah, I'm here.
I asked Courtney this question. I'm going to ask you the same question. Obviously, a best case, worst case scenario. Best case is, or worst case is you get your case defense. How do you see your best case? What does that look like to you?
My best case looks,
and be candid with me. Be candid.
Sure. Sure. I think the best case is, you know, she's 38 years old. She's college educated. So, you know, she has experience. And I imagine that she can probably find a new job probably fairly quickly. So, that will reduce any future potential wage loss. So, best case scenario, somewhere between the 5 and the 750 that I've demanded, I think is the best case scenario. I think if they buy her story and believe that Macho Mike's conduct was severe and pervasive as we allege, and then they're looking at punitive damages, and maybe not much from Mike because maybe he doesn't have any money. I don't know, but I still got Merch Co. On the hook for that too. So between 5 and 750, I think is very realistic at trial.
That's best case.
Best case.
All right, I'm going to have you pull your crystal ball out if you can and take a look. And how many times out of 10 do you think you get your best case, and how many times out of 10 do you think you get substantially less than that?
7 out of 10.
Okay. Not the best odds.
No.
Your client is aware of those risks?
Yes.
Okay. More realistically, I think your best day is probably somewhere around 300,000 to 400,000. That's my gut. Given the county you're in, given all what you've said, and given the factual disputes that I'm seeing, I don't know that you ever get to the top of the line. I think that your best case is substantially less, but that's my opinion for whatever it's worth. Take it or leave it. With that in mind, I'm hoping that I'm trying to give you some guidance in terms of where I think the case should be positioned to try to settle. I hear what your client's saying, and these cases oftentimes are highly emotional, especially when you sit down in front of 12 jurors and have to tell the story. It becomes even more emotional. It's a tough road for a plaintiff to do, and I hope your client is aware that is not something that I think she should want to have to do. I think that should be something that would be the last thing that you'd ever want to do, if at all possible. So with that in mind, I mean, I'm hoping that we can find some place that is more realistic in terms of the number. And I don't know what the other side's willing to do or able to do at this point in time, so I can't guide you as far as that goes. But I do want to let you know that I don't know, have you done any written discovery yet?
Just your basic written discovery, special rogs, form rogs, employment rogs, and so request for production.
Okay. Are you familiar with insurance coverage issues?
I know that there's probably, I've done defense work, and so for these types of claims, I typically know there's a reservation of rights, certainly for punitive damages and intentional conduct, but I haven't seen any reservation of rights. I only assume there is one. And I don't even know, as I think about it, I'm not even sure, I recall at this moment what the policy limits are. So I would need to be refreshed on that before I can certainly counsel my client on anything. But regardless of what the limits are, I made a policy limits demand early on. So if they didn't accept it, I don't really care what the limits are, because in my view, the policy's opened. But let me go back to what you were saying about kind of your view of the case, and I respectfully disagree. But if that's where you're looking, I mean, it's not unreasonable. I mean, that's certainly a fair range, given my experience. The problem is going to be my client. Getting my client in some realm, is assuming that can get the case done, getting my client into that posture. Extremely emotional. She would prefer to have her day in court so she can explain this, so she can out Mike in the conduct that he's been undergoing or undertaken with me, with this other employee there, and how Merch Co just kind of swept it under the carpet under the guise of a independent investigation. I mean, no independent investigator could have found it contrary to there being, sexual harassment. It clearly was. The email shows it. So she wants to be vindicated. And so, trying to get her off the ledge to come down into an area that you're talking about is going to be extremely difficult. I think maybe her expectations were unrealistic, perhaps. But I've had that conversation with her about having to sit in front of the jury and tell your story, and to people you don't know, might be embarrassing. Who knows what they're going to think, but she relished the idea. She wanted to do that. And I'm like, okay, if that's what you want to do, I'm fine with that. But recognize, we're here trying to settle the case, so you got to be flexible and compromise. So that's where I'm at. I mean, in terms of my client,
You know your client best. Do you think it would be helpful for her to talk with me and to get it off her chest?
I'm going to kind of defer to you on that one. I mean, like I said, trying to get her into that realm of where you're thinking is going to be extremely hard. If you think that you talking to her would help, then I'm okay with it. I just know that I've just knowing her and kind of the way she's responded to this, the claim, and kind of their response to all the allegations has kind of set her off. And so I want this to be productive. If you think that will help, and it may help her get it off the ledge.
Let's put it in the back pocket for right now to see whether or not I'm trusting that you have complete client control over her, and I don't want to interfere with your relationship with her at all. If my involvement or my conversation with her would somehow be counterproductive. So I'm gonna defer to you on what you think is best as far as that goes. I was told by Courtney the reservation rights letter does in fact exist, as well as that there's a policy of only 200,000. Courtney's not aware of whether or not the carrier is standing on those rights, or whether they're going to move forward with it, some sort of a debt relief action or anything along those lines. So that's good. At least we don't have that. We still have a live carrier involved. I don't know what the temperature read is as far as the carrier unwilling to pay substantial amount of money in this case, for example, up to policy. But I'm going to try to get that information next time I talk to Courtney. But I just wanted to get a read on you as to whether or not, your numbers are something that your client is hard and fast on, if that's the realm we're looking at, or am I getting a signal that you're willing to negotiate, you're willing to come off that number, and you have enough client control to be able to have to get your client to sort of move down off of those numbers and to avoid having to go to trial?
Well, I guess, I'll give you my lawyer answer. It depends. What are the policy limits? I refresh my memory. I thought
it's 200,000. It's 200,000.
Well, that's going to go over like a load of bricks. I can tell you right now.
Okay.
If that's the case, someone is going to need to write a check above and beyond that 200,000 in order to get this thing settled. And
okay.
if I have to depose Mike's wife and tell her about all these allegations, maybe it's Mike. I don't know. I'm going to do it, but 200,000, that's not going to cut it.
All right. I want you to think about that, because there are limits and parameters of which neither you nor I can deal with or adjust. They are what they are. You're going to run into collectability issues beyond the policy with Mike. Obviously, I think you recognize that you're going to run into collectability problems with the company as well. As you and I both know that's how difficult it is to collect on a judgment these days. So I want you to think about that, and I'm going to go talk to Courtney for a few minutes. Okay.
They're going to come back with an offer?
Yeah, I'm going to get a number from her.
All right.
That's it. Yeah, exactly.
Okay. Thank you.
Yeah. Hey, Courtney.
Hi.
Yeah, I'm trying to get a temperature read on the room with Bill. Right now, his client seems to be highly emotional, and so we're working on that. I think part of the issue is the fact that Bill's made a demand, significant as though it may be, but I think that a move from your side would be worthwhile at this point in time to let them know or send a signal to them, and hopefully a signal that you and the carrier and the company are serious about trying to get this thing settled. Their demand is $750. I'm getting pushback from Bill regarding numbers in the range of the policy, but I'm trying to get him to understand that winning the battle and winning the war are two different things, and that his ultimate battle is going to be, if he were to win anything beyond the policy, would be the collectability problem that sits out there. And so he could theoretically end up spending way more money than is collectible in this case. And I'm trying to get him off of understanding that. And I think he is. But I'd like to come back to him with a number that makes sense and that you're comfortable with, but also that sends the right signal. Okay. Did you have a number in mind that you wanted to start with?
Well, I had a number in mind, but I'm not sure it's gonna send the right signal, as you said, or you won't feel it does. We're really struggling with this being a valuable case. It's like I said, there's no reason why she shouldn't already be employed. She didn't even talk to anybody at the company about these supposed events until after she received a negative performance evaluation, which I think is a problem for her. And if we didn't have these personal exposure issues, I don't think this is anywhere near a $200,000 case. So that's what I'm struggling with. I normally, go ahead, sorry.
It seems to me you've also got the exposure of his attorney's fees as well. So that's sitting out there as well. So even a nominal verdict is going to result in a fairly sizable attorney's fee award. So I mean, I trust that that's going into your calculation in terms of what you're thinking.
Yeah, it is. And because of that, I think we would probably start with an offer around 50,000, recognizing that we may not have a lot more room to move. So what do you think about that?
I think that's fair. I think that's a good number to start with. Obviously, it's a signal that you're for real. 50,000 is for real money. And I also think it signals the opposite of that, which is, but we don't have a lot of room to move with, given the parameters of what your policy provides, and also the issues that are the reluctance on the part of the carrier to want to go, all the way in at some point. So what I'd like to do is, am I authorized to go back to Bill with 50?
Yes, that's fine.
Is there anything else that I need to, any other terms that you feel as though that we should probably get on the table now? If not, then I'll just let him know the number.
No, I can't think of any other terms.
Okay.
Yeah.
All right. Let me go talk to Bill and I'll be right back. Okay.
Okay, thanks.
Hey, Bill.
Hey.
I got a number. It's not a bad number. I don't think. I think it's actually it's an interesting signal. It's 50,000. There aren't any other terms that they have attached to that number, so it's just right now they're just it's just a fairly clean deal. But it's $50,000, obviously paid fine through the carrier at this point. They, to be fair, they recognize their exposure is not just the liability side, but also the attorney's fees. I truly believe Courtney's a good lawyer, and I believe that she's fairly evaluated this. I think that my sense is, and she hasn't said this to me, my sense is that there's other issues that she's bumping up against that are causing her to negotiate the way that she is. But I don't have any question, and there's no doubt in my mind that Courtney's evaluated this properly and is doing the best she can with those numbers. So the number to you is 50,000. What are your thoughts?
You need another zero to get this thing done.
You're killing me, Bill. You're killing me.
I know, but I'm telling you, I don't see it their way. You know, the temporal aspect of this alone. They're never going to get summary judgment, so I'm not worried about that. I think
She
that
knows. I think everybody knows that.
in and of itself is tribal issue fact. Certainly on a retaliation claim for sure. Um, you know, $50,000 for a year's worth of sexual advances, that's kind of a slap in the face. That doesn't even cover, you know, her salary for that year. So, you know, and I recognize the mitigation issue. I mean, so, but I'm really focusing on what she experienced and the trauma she experienced in that year, after having 3 good years with this company that she liked working for. But she felt that they just abandoned her when, you know, Macho Mike, the 10-year guy, supervisor, you know, got called out on his, excuse my language, is bullshit. You know, now they're backed to a corner, and, you know, she just feels like they turned their back on it. And, you know, that's not right. So
There's an argument to be made that her termination had nothing to do with Mike, and that she more or less just got fed up with the place and wasn't making enough money. I mean, there's all sorts of ways of trying to spin that. And so she's been out of work for 3 months. So that is, and the argument would be, I think, would be that it was of her own doing. Just playing devil's advocate with you, that
Sure.
could be the opposite side, which would reduce the potential downside exposure. And then there's always the possibility that a jury looks at this and says she's just being overly emotional about this, and that it was really no big deal. There's that component too. I mean,
Sure.
I know that you're a good lawyer as well. You've taken this all into consideration, that you can get a lot of different opinions from a lot of different people sitting on a jury panel in terms of what is or isn't harassing conduct. You and I both know that you can see that in different ways. So you recognize that there are people who will not view that a couple of advances, which she didn't take and didn't involve any touching. It was just mostly verbal, is the way I'm hearing it. That maybe she's just being a little bit oversensitive. That is one way it could be viewed. I'm not saying that's the way it would, but I'm just saying that that's a possibility. So with that in mind, that could affect your value of the case going forward.
You know, it could. You know, I get that. I mean, you know, I'm not sticking my head in the sand and ignoring what a jury could do. Yeah, I get that. You know, the problem is, you know, my client doesn't get that. And no amount of conversation I have with her will help let that sink in. So, you know, I'm kind of going back to your original thought about talking to my client, and, you know, I recognize the risks involved here. I may be inclined to let you talk to her, just to have her hear it from somebody else. Because yeah, I could try this case, and, you know, maybe I win, maybe I don't. But doesn't, you know, if I don't win, obviously it doesn't help my client at all. I'd much rather see her get something so she can get on with it, her life, and do bigger and better things. But I'm going to need help.
Okay.
She won't listen to me if I try to go. When you tell her it's $50,000, or I tell her it's $50,000, she's going to go ballistic. I mean,
Do you have authority to negotiate down?
I do. I have some authority. Yeah, I mean, I have authority to go to 500, but
Okay.
you know, that's about where I'm at right now.
Am I authorized to make that offer?
Yeah.
Okay. All right. Let me go talk to Courtney and let her know that that's where the number's at. Okay.
Okay.
All right. Hey, Courtney.
Hi.
Yeah. I'm not surprised. Bill's a strong lawyer and a really good trial attorney, and so he's playing this pretty close to his vest right now. His number he's come down 250,000 to 500. I think that's a good signal. I think that's a very positive signal from them, because I think what they're doing is that was a significant move downward. He is indicating that his client is, there's going to be a point where she's going to start standing pat, and she's not going to want to try to move. I don't think we're there yet. I don't get that sense. I get the sense they're still willing to talk. And I'm really trying to convey to Bill the fact that you know, as much as he thinks he could win the case, he could just as easily lose this case. Your case is not that weak. There's just a lot of circumstantial evidence. And ultimately, it's going to depend on a dozen people who are going to hear the matter and who may not view this as being anything other than just normal office conversation going back and forth. And if that's the case, then they may just, you know, accuse her of being she's overly sensitive. Bill's aware of that. He understands that that's a possibility that can happen. I said, I'm not trying to prejudge. I'm not here to decide anything. I'm just saying, I think we've all seen where juries have made decisions that have been a little baffling in some sense. On the other hand, makes perfect sense given their own personal life choices. So with the 500,000 that's on the table, what are your thoughts about that?
Well, I agree. I think it's a decent move. I still think they're way up in the stratosphere. Is she here? Can I ask that?
She's available. I haven't spoken to her right now. I kind of get the sense Bill has been, I don't know whether she wants to talk to me or whether Bill's having difficulty with her. I'm not sure what the deal is there, but Bill has indicated that he'd allow me to talk to her. I haven't taken him up on that offer yet. I think what I'd like to try to do, what I'm trying to do, is see what we can do with the numbers before I go and have that conversation. There may be a time where I have to have that conversation with her about about when we get to, I think, crunch time, whether or not that would do well. She's a very spirited, from what I understand. She wants to tell her story. She's not afraid of coming into a courtroom. I think that could change the closer they get to trial. I think that oftentimes does, is people all of a sudden the nerves and becomes a little tougher, and you know, as time goes on, it's more and more difficult. And so oftentimes what looks like it's no big deal today, when you get closer in time, becomes a little bit more traumatic and difficult. She's not there yet. But again, I think we have an opportunity to try to bring the numbers closer as we can. I want to ask you for a counter demand if I can. Can you give me a number in response to their 500?
Yeah. Yeah, no, I find it a little strange that she wants to tell her story and she's not here. But recognizing that they did make a pretty decent move, I think we can go to 75,000. Okay.
I don't know that that's going to be well received, but I'm going to go ahead and take that to them and see what we can do. Okay.
Okay. Thank you.
Right. Yeah. Hey, Bill.
Oh,
yeah. I had a feeling we were going to get to this point. We're running into I think the carrier is viewing this wildly different from how you see this. They've come up to 75. I don't think that's their last number. I'm pretty sure it's not their last number. I'm not getting that signal from Courtney, but I do think that that is a signal that they're probably trying to work this out so that the settlement would fall within policy limits and not go beyond that. And I know that's not where you're going with what you're shooting for. But I do want you to think about that you know, today's the day that you have an opportunity and your client has an opportunity to really put this thing behind her, and that you know, she's going to have sunk costs in this case going forward, and and by that I mean a lot of time and a lot of her own costs and that sort of thing. But you're going to look to have her pay the costs going forward. She's going to end up having those things, and doesn't sound to me like she's in a position to be able to do that very easily, which means either you go, you know, 100% in and take the risk, or share the risk with her. But if you share the risk, she's going to have a problem, I'm sure, trying to fund that. But I do think that there's an opportunity to try to get us as close as we possibly can to the policy, if not the policy. But I need to get a signal from you as to whether or not, if we were to do that today, and this was something that your client could feel comfortable that she's closing the door on this chapter in her life and she's able to move forward with some money in her pocket, whether or not that's something that we can do today. Is that something that you would be comfortable with and she would be comfortable with? I know that's a big drop, but I'm not asking for a number. I'm just asking for, your sense, your feeling from her.
Well, first of all, I would have to take a substantial cut in my fees, which I don't typically do, number one. And I think her expectations are, she has to have at least 6 figures in her pocket to make this work. What that six figure number is, I don't know, but obviously somewhere, it's not, ideally would be 500, ideally would be 750, but we recognize that that's not going to be the case. I don't know that I would ever be able to get her to $200,000. I mean,
let me ask you this. Let me just stop you right there, because let me see. Courtney hasn't given me authority, and I don't know whether I'm going to get it, but if I were to get you the policy limits, and honestly, that's the, that may be, it's unfortunate it's only 200,000, but that's what it is. If I were to able to get you the 200,000, would you recommend that to your client and say, yeah, I think you should take this because I think it's important to try to shut this thing down? Would you do that?
I think the only way that I could do that ethically, at least from my perspective, is I would need something from Merchco and Macho Mike that they have no assets. Because if they have any assets and I'm committing malpractice, I'm not going to do that.
I got you. So if I were to get some sort of get that information as well as a commitment from the carrier to pay the 200,000, you'd recommend that to your client? And assuming obviously that there are no other assets available.
Right. If that's the best that she can do, I would recommend it. But I'm going to need your help there, because I know that she's going to go ballistic.
And I don't have that from Courtney's side either, so I need to go talk to her and see if I can get that from her as well. Okay.
Right.
So let me go talk to her. And again, I'm not committing you to anything. I just wanted to get a sense. Okay.
Sure. No, I understand.
Okay.
Yeah,
Courtney. All right. He didn't give a response counter to your number. But let me ask you this. Do you believe that there's a carrier could get to 200,000? I mean, Bill's indicating that he would possibly be willing to go to accept the policy limits on the case, provided that he also gets a declaration from the company as well as from from Mike as to their financial assets and status. Obviously, that would be done within the mediation context, so it would be strictly confidential. But if you were to go to the carrier and say, listen, $200,000 and the financial information from Mike as well as the company as to their ability to pay an excess judgment, and I'm assuming that they would be able to do that or be willing to do that. But if they were able to do those two things, would you recommend to the carrier to go ahead and pay the 200,000?
I as I said, I do not have that authority today, but I would recommend that. And I think that both of my clients would be willing to do those declarations.
Okay, so I'm not committing you to anything. I'm not asking you to make that as a counter to anything. I just wanted to talk with Bill to be able to give him a signal that Bill, if your client is willing to go there and the carrier is willing to accept your recommendation and the company's willing to provide these additional financial information, that I think that you are going to likely have a deal. And again, I'm not committing anybody to anything at this point in time, but I think what we see is there's a roadmap there in terms of how we could possibly structure a deal that might make sense. And obviously you got some homework to do with your clients And Bill's obviously going to have some homework to do with his clients, and I'm going to remain available to work with you and all of you to talk. And if you need me involved with the carrier, I'm happy to do so. But to try to work through these issues to see if we can't get to the dollar amount that's agreed upon, and then provide the additional information that Bill satisfies Bill's concern as to whether or not he's leaving any money on the table. Okay.
I will recommend that to my clients.
Okay.
If they're willing to accept that deal, then I would recommend that my clients accept it as well.
Okay, sit tight. Let me go talk to Bill and make sure that he's on the same page, and then we'll go forward.
Okay. And we have a lot of questions in the chat if we leave a few minutes at the end.
Yeah.
Thanks.
Hey, Bill, Courtney's willing to recommend it exactly as you had provided. Obviously, nobody's going to be committed to anything. I will told Courtney, I'll tell you the same thing. I will remain involved with the process to continue to and talk with your client to try to move her in that direction. But I think that if you're willing to, if your client's willing to accept the policy limits plus the declarations or information from both the company and Mike, Courtney's going to work with us to try to get that to happen as well. Okay.
All right.
All right. So
that sounds good.
Okay. Katie, with that, I'd like to turn it back to you.
Great. That is me. Would you like me to launch our poll here into the audience, Peter?
Yeah, please do that.
Great. So we have the proposal out on the table, and I am going to launch a poll to everybody here in the audience to get your feedback. The question is, should the insurance company take the offer that's on the table? So you got a little pop-up on your screen there. Feel free to give your response, the yes or no. And once we get some answers, we'll see what people think.
And Katie, are there questions that we can help with?
There are a number of questions. One of them was pretty general for the associates in the audience. If an associate is attending a mediation when the partner does most of the talking and the negotiating, what advice do you have for them? Really, they're asking, how can an associate be impactful in pushing for a resolution in that situation?
Truth be told, and I think Bill would agree with me and Courtney as well, is that the associate typically knows more about the case than the partner does.
Exactly.
And that is a plus. So you need to step up and sort of insert yourself and say, hey, listen, I've got more detailed information about what's going on. And your partner should be willing to go ahead and allow that to happen, because one, it allows you to get some to speak up during the mediation process, but two, your insights and your background and your understanding of the facts of the case are invaluable to the mediator for us to be able to move forward. If the partner doesn't know certain questions, and it happens all the time where we're answering questions or getting questions, or we're asking questions and we're not getting any response because if somebody says, well, I don't know, that I never asked the client that question. To have somebody there is invaluable. So
yeah, I would agree. I would agree.
Up.
That's your place to shine as the associate, because you do typically know the facts better than the partner for the most part at that stage. And so don't feel, I mean, you gotta kind of maneuver a little bit, because you don't want to make the partner look bad. But you come in when to fill in the gaps. I mean, the media can come back and say, well, they said X, Y, and Z. How'd you respond? I think that's a perfect opportunity for the associate to say, well, we have these 7 emails that are contrary to what they're saying there, and there are exhibits 3, 4, and 5, whatever. That's a perfect opportunity for the associate to come in and fill in the gap where the partner may not have that granular level of knowledge yet.
Yeah, and I think that the partner is probably going to be willing to listen to what you have to say. Otherwise, they wouldn't have you there with them.
Exactly.
I do want to share, we got the results from our poll here. So the feedback was that 85% of our audience thought that yes, the insurance company should accept the offer, and 15% thought no.
So so it looks like I have 50% of plaintiffs' lawyers sitting out there, at least. Ones that
there was
go
one-
to trial, ones that said, no, roll the dice.
Yeah, there's one question that I saw in the chat that's about, my client I was being difficult about not letting the mediator speak to the client. I, as a mediator, always want to talk to the client, and I would encourage the lawyer. I would take the lawyer out of the room and say, "Hey, Peter, I think it's really important for me to talk to your client, and here's why." Because I think, as Peter mentioned, and I think we mentioned the last time we were together, it's important for the party to have their say, because they're not really going to get it any other place. And so I think it's crucial as a mediator to be able to talk to both parties.
We had somewhat of a related question that Courtney, I saw you pinged, that said, seems to me that the plaintiff needs to hear the mediator's comments rather than having them relayed by counsel.
Yeah.
Unfortunately, this format doesn't allow us to do that. That was the only reason. Otherwise, I would have. And ordinarily, what I do is I spend a good deal of time with the clients, both sides. And I think a good mediator does that, spends time with both sides, really talking to the clients, those people who are the decision makers, and those whose fate is in somebody else's hands, and be able to really get a feel for who they are and their story, and allow them to be heard.
Yeah, because you have along those same lines, the mediator only knows what he or she's been communicated by the parties in briefs. So, and maybe the mediator doesn't know both the lawyers, maybe only knows one of the lawyers. You got to be able to develop that trust with not only the lawyers, but with the parties themselves. So, and I think it's important, and oftentimes lawyers want the mediator to tell their client the way it is, in terms of the way that the mediator sees it. So the client can hear the mediator's comments directly, as opposed to being filtered by the lawyer.
Yeah, we talked at the first session of this a couple of weeks ago about how it's a really good opportunity to get a neutral third party's opinion of your case. And it's definitely sometimes helpful. Sounds like it may have been helpful in this case for the plaintiff to hear that. And the defendant, you'll want to try to have if you're a defense attorney, have your clients at mediation also.
Yeah, agreed.
We had one here that was interesting as well. How far apart is a good time to propose brackets or a mediator's proposal? That's kind of a question for you, Peter.
It depends on the situation. It really kind of, you have to read the room and figure out exactly where the parties are. If you're miles apart, there's no point in doing it. If you start getting closer and the mediator gets a feel that I just need to ooch them a little closer, then brackets come out and they're helpful. But it's a two-edged sword. Brackets can also be counterproductive, because the moment you propose them, you can have people saying, well, there's no way on God's green earth I'm ever going to get to that number, so don't even bother. Right. So it really comes into understanding exactly where people are, what their motivations are, and where the process is. It can't be done too soon. It has to be done later on to try to close the gap, I think.
Yeah, I think, I'm not a fan of brackets, because oftentimes when it comes up, the parties are too close for really a bracket to be effective. And if you're too far apart, they're not effective either. I think it's really dependent upon the parties and the lawyers and the situation. Will that nudge them together? Maybe. And so you, as the mediator, have to have all those tools in your pocket to do that. I kind of go with the approach that Peter does. When you're getting close, as opposed to brackets, I start thinking about, what if I can get them here? Would you be willing to accept that number? Where no one's making that offer. It's just the mediator's getting a sense of where the case should land, and trying to get some buy-in from both sides as to whether or not that number would work, or something close to it. And I found that to be more effective than doing brackets.
And I do want to be conscious of people's time, but we had a question that I wanted you to address about pre-mediation. work and calls? I know that's something that you normally do. In the interest of time, we didn't do those calls, but can you talk just a little bit about the value and kind of what would be talked about at a pre-mediation call for this situation?
That's I do it in all my cases, and I think Bill does too. And Courtney as well. I think we all rely on that to be able to use that as sort of a forum that is outside the ears of your client, where the lawyer can be real candid with the mediator, and I can ask really candid questions about their case, and dig deep and procedurally, where are we at? What are the facts that have been developed? What are the weaknesses in the case? What are the strengths in the case? What's your thought process and how you've evaluated the damages, that sort of thing. We sort of go into all that so that at the day of the mediation, really we're focusing on not trying to learn about the case, but we're really trying to take what we know and begin to move the ball forward and move the case forward towards resolution. It's counterproductive. It's always been counterproductive to try to learn about the case during the mediation. You want to do that all beforehand. That's why I encourage the lawyers to be really candid with me, even on a confidential basis, perfectly fine, but just be really candid so that I can see all the warts in the case. I can see the good parts and the bad parts, and it helps me to begin to formulate a plan in terms of where I think the case can go and how it should be handled.
And to follow up on Pete's point, there is, in this scenario here, I was having client control problems, and that would have been a perfect opportunity in the pre-mediation call for Peter to say, "Hey, Bill, do you have any client control issues?" And I could say, "Yeah, I'm going to need some help here. My client's way up here, and I recognize the case is probably, in this range. So I'm going to need your help." That's the perfect opportunity to have those discussions.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.